Judicial discretion. When does judgment begin to replace the law? This is my personal reflection on the YouTube video linked above. What is judicial discretion in the justice system? The purpose of this reflection is not simply to summarize the video. It is to examine the ideas it presents and the questions those ideas raise for me about law, justice, equality, and judicial power. The first slide presents judicial discretion as the authority of judges to make decisions based on their own judgment and interpretation of the law. That description immediately raises an important question. What comes first, the law or the judge's interpretation of the law? If a decision begins with the judge's judgment and interpretation, then the law risks becoming something placed before the judge to be shaped rather than something that independently controls the judge. The slide then explains that discretion allows judges to tailor decisions to the unique circumstances of each case instead of strictly following legal statutes. That is an extraordinary idea. A statute exists precisely to establish a rule before an individual controversy reaches a courtroom. If a judge may decide that particular circumstances justify departing from strict adherence to that rule, then the controlling authority has shifted. The statute no longer determines the result by itself. The judge determines how much authority the statute will have in that particular case. The slide also discusses sentencing and tells us that judges may consider the defendant's background and the nature of the crime. Those facts may certainly be relevant. But something important seems almost absent from the description: the law. We hear about circumstances, background, the nature of the offense, and the judge's judgment. Yet the law should stand above all of them. And this brings me to Themis, the traditional symbol of justice. Her eyes are covered because justice is supposed to begin with rules that do not change according to the identity of the person standing before them. The judge's eyes, however, are open. The judge observes the circumstances, evaluates them, interprets the law, and then tailors the result. So the first major question raised by this video is simple. Who is really in control, the law or the person given discretion to decide how the law will apply? The second slide says that two people convicted of similar offenses may receive different sentences because of the specifics of their individual cases. That sounds reasonable until we ask, what exactly are those specifics, and who decides how important they are? The offense may be similar. The law is the same. Justice is supposed to be equal, yet the results may be different because the decisive element becomes the judge's assessment of circumstances. And the word specifics tells us very little. It can include whatever factors the judge considers important, and the weight assigned to those factors exists largely within the judge's own evaluation. The same law can therefore produce very different outcomes because different judges see the same type of case differently. So where, exactly, is equality before the law? The slide then says that discretion allows justice to consider broader context, not just the letter of the law. But that creates another problem. Which comes first, the law and justice, or judicial discretion? If discretion is what supposedly ensures justice, then discretion has effectively been placed above the law as the mechanism deciding what justice requires. The statement assumes that written law may be insufficient and that a judge must improve upon it by adding broader context. But who decides when the law is insufficient? The judge. Who decides what broader context matters? Again, the judge. So the hierarchy begins to look very different from what many citizens probably imagine. First comes discretion, then interpretation, and somewhere beneath both sits the written law. The slide also says that judges operate within a legal framework, but the word framework itself is broad. Either the law controls the decision, or discretion controls how much the law will control the decision. Calling the surrounding structure a framework does not eliminate that tension. Themis does not hold a framework. She holds scales. Her eyes are covered because justice is supposed to apply principles impartially rather than adjusting them according to the personal vision of the decision-maker. The third slide appears more reassuring. It explains that judges cannot impose a sentence exceeding the maximum punishment established by law. Here, finally, the law seems to create a hard boundary. But even a statutory maximum controls only the outer edge of the decision. Before a case reaches that boundary, many discretionary decisions may already have shaped what happens. And then the video makes what I consider one of its most important statements. Discretion also applies to pretrial decisions. That point deserves much more attention. A judge may decide whether a person remains in custody or returns to the community. A judge may determine whether evidence can be used. A judge may decide motions that weaken, reshape, or even end a case. A judge may impose sanctions, restrict filings, decide whether procedural violations are serious or harmless, and make rulings that profoundly affect what the parties are later able to present. For a self-represented litigant, these decisions can determine the practical outcome long before a jury hears evidence or a trial reaches the merits. A person can lose money, lose evidence, lose procedural opportunities, lose the ability to present arguments, and sometimes effectively lose the case itself, all before trial. So judicial discretion is much larger than the power to choose an appropriate sentence. It can become control over the road leading to justice itself. The question is therefore not merely, how much can a judge sentence someone? The larger question is, how much can judicial discretion shape, or even destroy, a case before the legal merits are fully heard? The fourth slide acknowledges that judicial discretion can produce inconsistency and bias. That is not a minor technical problem. It goes directly to the legitimacy of the system. If the same law applied to substantially similar facts can produce materially different results depending on which judge receives the case, then inconsistency may not simply be an accidental defect surrounding discretion. It may be one of discretion's natural consequences. The video then reassures us that jurisdictions use guidelines and standards to reduce these dangers. But that raises another series of questions. Are those standards mandatory? What happens when they are ignored? Who decides whether they were followed? And what immediate remedy exists for the person harmed when they are not? A guideline without enforceable consequences may be useful advice, but it is not necessarily protection. And a standard whose meaning ultimately depends upon the same discretionary decision maker does not eliminate discretion. It simply gives discretion another vocabulary. The final idea is that the system seeks a balance between flexibility and adherence to legal standards in order to achieve fair outcomes. Those words sound reassuring. Flexibility, legal standards, fair outcomes. But each of them is elastic. What is flexibility? How far may a judge depart from an ordinary result? What are legal standards? Binding statutes and rules? Advisory guidelines? Precedent? General principles? And what exactly is a fair outcome? Fair according to the legislature? Fair according to society? Fair according to the parties? Or fair according to the individual judge? Without a firm connection to enforceable law, these expressions can become polished language surrounding a very simple reality. The judge chooses. And that brings me to the central contradiction I see throughout the video. The law is supposed to establish the rules. Justice is supposed to result from the impartial application of those rules. Yet we are repeatedly told that discretion, flexibility, broader context, standards, and individual judgment are necessary to produce justice. So which comes first? Does law define justice and constrain judicial power? Or does judicial discretion decide what law, justice, fairness, and legal standards will mean in the individual case? This is why I keep returning to Themis. Her eyes are covered, not partially covered, not covered only when convenient. Covered. The symbolism is simple. Justice is not supposed to look at the person first and then decide how much law that person should receive. The law is supposed to stand above the decision maker. Guidelines and standards are meaningful only when they genuinely constrain judicial power. Otherwise, they risk becoming decorative language surrounding discretion. And fairness without enforceable law can ultimately become whatever the decision maker says fairness means. That, for me, is the real question raised by this video. When judicial discretion becomes powerful enough to determine how much the law controls the case, are we still governed by law or by the judgment of the person interpreting it?